Hi, I'm Jesse Bifulco of the LifeCounsel podcast. I'm an estate planning lawyer who tells stories. I've saved my clients hundreds of millions of dollars over the years. That doesn't include the value to those families of the fights that never happened because they had a great estate plan. But most people will never save that money. Most people will not avoid unnecessary family fights because they think it's too complicated to get a great estate plan, or they don't see the value in one, or they get their advice from the wrong people. But you'll find out, as my mom used to say, by hook or by crook, because you'll find out either at the wrong time, that is during a family crisis, by walking blindly into an estate planning pitfall that burns up your family wealth and magnifies the cracks of fragile family relationships. Or you can find out the painless way by listening to my podcast instead. I'll show you where those traps are laid out for your family before it's too late to avoid them. I'm going to reveal to you why a goal-driven professional estate plan is one of the smartest investments a family can make and how you can make one. Today I'm going to reveal the 5 most common estate planning mistakes. In my law practice, when someone or a married couple will make an appointment, they're not talking the way I talk. They don't say, I need to discuss my estate plan. They say, we want to change our will, or we need a will, or we want to review our will. I'll say to them, well, how about we talk about an estate plan instead? You'll hear me say this over and over again, but it's true, and most people don't get it. So I'm going to say it one more time. A will or last will and testament is not an estate plan. A will is a set of instructions about what to do with your property after you die. A plan consists of strategy and tactics that support a goal. Remember, a plan is more than just a document. It's a strategy and tactics that support a goal. Today, I'm going to reveal not just the 5 big mistakes that cost people money and cause family fights, but how you can identify those mistakes in your own plan, or lack thereof. Because it isn't always easy to see where the mistakes are hidden. The secret is this: once you define your goal, the mistakes will show themselves. I'll prove that it's true. I'm going to tell you a goal, and like magic, the instructions are going to arise in your mind. Are you ready? Your goal is to go to the post office and mail a letter. Do you see in your mind the steps involved in achieving that goal? Once I tell you that the goal is to throw a successful dinner party, the steps or the strategy and tactics reveal themselves. Once you decide that your goal is to have a successful hike to the top of Mount Washington, the steps to achieving that goal reveal themselves. The same is true of estate planning. Once I reveal the goal, and I'll use a generic estate planning goal to start with, then you'll better understand the steps needed to achieve that goal. In LifeCounsel, our system of estate planning is goal-oriented, which means rather than point to a specific document like a will or a trust or a power of attorney, we're going to first define what the goal is, then the strategy, then the tactics. If you think that sounds complicated, it's really not. Here's a simple everyday example of how that works. I'll show you by defining a goal, then the strategy and tactics. Let's define the goal. Okay. The goal is to improve your personal health. The strategy is the big picture way that we're going to reach that goal. So, what's the big picture way we're going to reach the goal of improved health? In order to improve personal health, the strategy could be to adopt a healthier lifestyle through consistent exercise and improved nutrition. Okay, so then what are our tactics that are going to support that? Remember, we have a goal, strategy, and then tactics. The tactics are the specific actions necessary to carry out that strategy. Our tactics might be walking 30 minutes every morning, or replacing processed food with home-cooked meals, and scheduling a weekly workout at the gym. What might an estate planning goal look like? Well, let's use this as our example goal. To maximize the inheritance to your children while protecting your surviving spouse. If your goal is to maximize what you pass to your heirs without compromising protection for your spouse, your strategy should be about minimizing taxes, avoiding probate, and shielding your assets from creditors and unnecessary costs. The tactics, the actual steps, include carefully designed trusts, strategic gifting, and thoughtful beneficiary designations. Together, these actions can make sure you meet your goals and your family wealth stays exactly where you intended. In a minute, I'm going to illustrate the top 5 most common planning errors. But listen to the end when I reveal a 6th pitfall that can cost you your entire estate if you don't get your planning right. Okay, so let's get started with the top 5 most common planning errors. Let me introduce you to Jake. Jake went to an estate planning seminar. His financial advisor invited him. The financial advisor invited a prominent estate planning lawyer to come and talk to his clients. Jake sat and listened. He had the chicken. When the lawyer moved to the question and answer portion of the seminar, Jake raised his hand and asked this question. Mr. Lawyer, you said that if I don't have an estate plan, there's a statute that governs my estate. So what you're saying is that even if I don't have a will, if I should die, my wife is going to inherit my estate. And the lawyer answered, well, technically that's correct. Jake cut him off and said, okay, so you also said that even if I don't have a will, if me and my wife both die, our assets will pass to our children. The lawyer again answered, that's true, yes, that would be the result in your state, Jake. So having teed up his final pronouncement, Jake was ready to move in for the kill. So, Jake continued, Mr. Lawyer, even if I don't have a will, my wishes are going to be carried out. Do I really need to spend thousands of dollars on an estate plan when the statute's going to do exactly what I want? Well, Jake went home feeling as though he had a successful day. He got a free chicken dinner and showed that lawyer that he was smarter than him, even without a law degree. A few years later, Jake's wife, Thelma, had a stroke and went into a nursing home. Needless to say, Jake was very upset. Thelma was Jake's support in many things, and without her, he deteriorated quickly. A couple of years later, Jake died. As per the statute pointed out in the seminar, all of Jake and Thelma's assets passed to Thelma. Jake and Thelma's 3 children fought about who should be in charge. Sarah, the daughter, who was an RN, thought since she had a medical background, she should be the one to make decisions about their mom. Paul, the middle child, sided with Sarah. The oldest, William, a financial advisor, thought he should be in charge because he's good with money. Both Sarah and Paul petitioned the court to be their mother's legal guardian. Both Sarah and William petitioned the court to be the executor of their father Jake's estate. After spending a bunch of money, duking it out, and just before the hearing, the two made a settlement agreement, and William got to be the executor and also was put in charge of the financial decisions for his mother, Thelma. Subject to Sarah's consent to big decisions, and Sarah got to be the guardian who makes living and medical decisions for her mother, Thelma, subject to William's consent on big decisions. So here's common mistake number 1. Not having an estate plan. Common mistake number 1. Apparently 60-something% of people don't have any estate plan. So common mistake number 1 is not having an estate plan. If Jake had listened to the lawyer at that seminar, he might have gotten more than just a free chicken dinner. He might have articulated his own goal. As you can see, relying on the statute increased the expense to Jake's estate, thus decreasing his family wealth. Also, relying on the statute encouraged his children to fight, where if he and Thelma had made a plan, they could have avoided all of that. So, most common mistake number 1 is not having a plan. Returning to Jake's estate. Once appointed as executor, which took a bunch of time, Jake's son William began to gather together all of his parents' important papers, trying to make sure that none of his father's assets were lost. While going through an old envelope in his father's safe deposit box, Jake found a life insurance policy. He wrote a letter to the insurance company. The insurance company returned the letter stating that they didn't have proof of William's authority or evidence that the insured had died, so they could not help him. William wrote another letter, this time putting in a certified letter of appointment showing that he was indeed the executor, as well as an original death certificate so they could see that his father had died. The insurance company replied saying, "Thank you, William, for proving the authority and death of the insured. However, since you're not the beneficiary, we cannot deal with you." Upon investigation, William discovered that before his father Jake married his mother Thelma, he had been married to another woman named Samantha. That marriage took place when Jake had first started to work for the big company as a new employee. And when Jake signed all of his new employee papers, by default he had made Samantha the beneficiary of his employment benefits, which had included an insurance policy. Jake didn't think much of it at the time because the benefits were small and he didn't intend to stay at that company for 30 years. But he had stayed there and the benefits grew, and now his ex-wife Samantha, who he hadn't seen since their divorce 3 months after their marriage, stood to inherit and receive $250,000 in death benefits. Most common error number 2, not reviewing your beneficiary designations. Now, don't rest upon this cautionary tale because it is an obvious example of a big mistake. The next question in your mind should be, well, who should be the beneficiary of that $250,000 death benefit? Should it have been Jake's wife, Thelma? Returning to Thelma, the surviving spouse of Jake, Sarah became her mother Thelma's guardian. Thelma lived in the nursing home for another 6 years after Jake died, incurring $1,116,000 in uninsured costs. This is most common mistake number 3, failing to plan for a possible period of incapacity before you die. Had Jake and Thelma imagined that before they died, one or both of them might experience a period of incapacity, they could have made a plan that addressed that possibility. Using the LifeCounsel system, the goal would be to prevent the exploitation or loss of wealth that might be caused by Jake or Thelma's incapacity. The strategy would be to create a legal plan that defines incapacity and designates people to make living and financial decisions during incapacity and incorporate legal asset preservation techniques to avoid unnecessary loss of assets caused by the incapacity. That would have avoided the guardianship battle, the probate expense. It would have protected Thelma and increased the possibility of an inheritance for their children. The tactics would be to create a living trust, a healthcare power of attorney, a financial power of attorney, and incorporate into those documents the appropriate powers necessary to carry out the plan. Returning to the saga of Jake and Thelma, Sarah, who is her mom Thelma's guardian, calls up her brother William, the financial decision maker, and says, "William, we need to sell Mom's house. She's not living there. It's costing us money, and I need cash to pay for her nursing home." It turns out that after the estate planning seminar, Jake deeded the house over to Thelma. He had gotten it into his head that she should own the house alone and not him. He was worried about being sued, and so rather than ask an attorney, he did a DIY asset protection plan and signed the deed over to Thelma. When William sold the house, because Thelma had not been living there for a while, they could not take the principal residence exclusion that would have wiped out the first $250,000 in capital gains. Jake and Thelma bought the house for $150,000, but now it was worth $750,000. Also, because Jake gave Thelma the house during his life, when he died, the property was not eligible for an adjusted basis. A big chunk of the sale price of the house had to be paid in capital gains taxes. Most common mistake number 4 is ignorance of tax implications. Believe it or not, there are more and less efficient ways to plan an estate in terms of tax efficiency. Some folks think that if they have a modest estate, there are no tax implications. If you have any appreciated property, that is property that you bought for less than it's worth now, right? That could be stock, it could be real estate. If you have any appreciated property, if your house is worth more than you paid for it, or your stock account is worth more than you paid for it, then there are tax implications. If you're interested in asset protection, there are also tax implications to that. If you have too much money, there are tax implications. If you just want to maximize what you've worked for and saved and managed for the benefit of your family, you had better take into account those tax implications. This part of the story also illustrates the fifth most common mistake, the dreaded DIY estate plan. We could spend hours on DIY estate plans gone wrong. Unlike some of the other mistakes where the mistake is caused primarily because you didn't have a goal, the DIY do-it-yourself estate plan mistakes are often caused by having a goal, but by adopting the wrong strategy and tactics. Maybe because the goal is too specific and narrow, or maybe it's given too much weight, or maybe the solution was just too complicated for you to understand because you're not a trained professional. Also, not understanding all the implications of an action can cause the do-it-yourself plan to go horribly wrong. In this example, Jake's goal was to avoid his own potential creditors from getting sued at his home and having his home be subject to liability for his creditor liability. You see, when the kids moved out, he and Thelma stopped visiting their beach house, so he started renting it out in the summers. He was worried because he thought if the tenant sued him, at least the family home would be safe. While premises liability for a rental property is a real concern, there are ways to accomplish protection without losing the step-up in basis or the principal residence exclusion. Another common, too narrow and misunderstood estate plan goal is avoiding probate. Yes, avoiding probate can save money and avoid fights, but it should not be considered the ultimate goal of an estate. Examples of DIY plans whose goal is purely to avoid probate is when someone does not take into account or talk to an estate planning attorney. They get it into their head that a quick and simple estate administration upon death, that is, avoiding probate, is the most important goal. So they have joint title on their house and make sure their investment account has a pay-on-death designation and joint bank accounts and beneficiary designations for everything, so that if they die, immediate ownership will vest in their surviving spouse. Yes, that avoids probate, but that result in this case means everything passes to a completely incapacitated individual, Thelma, who's in a nursing home. Not a good result, right? Is it a good result to have the assets left to Thelma? After all, she can't manage those assets. She's living in a nursing home. Even if Thelma was living at home, she's unable to manage the assets, and at least in my experience, often becomes the target of opportunists. In this case, Jake's DIY tactics did avoid probate, but they quickly put the entire estate at the ready disposal of Thelma upon Jake's death. But she's incapacitated and could not manage the estate anyway. This exposed the entire estate to Thelma's creditors when that could have been avoided. So, a DIY estate plan that, yes, avoided probate, it did that, but Jake's real goal was not to avoid probate. His real goal was to protect his surviving spouse and preserve an inheritance for his heirs, which he did not accomplish. Okay, so to recap, here are the top 5 most common mistakes people make, plus, as promised, for listening to the end, a 6th pitfall. Number 1, not having an estate plan at all. Remember, define your goal, then your strategy, then your tactics. That's the LifeCounsel way. Most common pitfall number 2, outdated beneficiary designations. Most common pitfall number 3, failing to plan for a temporary or indefinite period of mental incapacity. Most common pitfall number 4, ignoring tax implications of your gifting or property transfers. And most common pitfall number 5, the DIY estate plan gone wrong. Now for the bonus 6th most common mistake people make. The 6th most common is not using a vetted, experienced attorney who specializes in estate planning and elder law. Remember, the law is a very broad topic, and no attorney can be an expert in all facets of the law. This is just common sense. If you think I'm strongly suggesting that you work with a lawyer to make a plan, you're right about that. But not just any lawyer. You wouldn't use an internist to do your open heart surgery. You wouldn't go to an ear, nose, and throat doctor to treat your fracture. So why do you think just any lawyer you meet with can give you advice about your estate plan? In the next episode, I'll give you strategies to choose the best attorney to work with to ensure that you get an estate plan that will achieve your goals. I'll give you the top 5 tips in choosing your estate planning attorney. Thank you. I'm Jesse Bifulco, the host of the LifeCounsel podcast.